Hello and welcome to the third instalment of our seminar on employee use of social media, brought to you by Howard Avram Solicitors. Today we are focusing on the topic of how to protect confidential information. Whether you are an HR professional or a small business owner, the use of internet and emails by your employees can be a real headache, and knowing what your responsibilities are is important to avoid getting into a legal quagmire. Social media is now part of everyday life. It's the new normal, and with nearly 2 billion Facebook users globally, it's not going anywhere. However, it can have pitfalls in the work environment, and legal cases frequently occur. If I can start with a basic piece of advice, don't ignore the importance of social media in the workplace. Undoubtedly, employers who have in place appropriate policies and contractual wording will be better placed to protect the business than those who have not. The cases that have occurred to date and been resolved at court level are now defining what you should and shouldn't do as an employer. We're going to look at these real-life cases and provide you some checklists for action within your own workplace. As we said, this is the third instalment in 4 chapters on this topic. When we've finished this short seminar, make sure you move on to view the rest. So on today's hot topic of who owns your confidential information, we're going to look at examples in 3 areas that come up repeatedly. The first, employee contacts; second, passwords and logins; and third, social media job information and solicitation. For contacts held by employees, it comes up time and time again that an employee will believe that they have personally collected the contacts, therefore they belong to them. However, a case illustrated the opposite. A contacts list held by a journalist on his or on her employer's computer system on Outlook was actually deemed to belong to the employer. But what if an employer retains contacts in a social media account in a personal capacity? In this case, an employee deliberately migrated their employer's data to the social media account. The court decided that their contact details obtained during the course of employment remain the property of the employer. In our second example, with login details for managing company social media accounts, a recent case deemed that employees must release them back to the company when they leave. Finally, in the murky waters of LinkedIn job profiles and employees managing them for the purpose of trying to find a new employment while remaining employed, does updating their profile on LinkedIn when changing jobs amount to solicitation? Well, another case identified that it depends on the precise nature of the communication, the content of the update, and the intent behind the communication. The court in this case found that it was an unlawful restraint of trade to prevent a former employee from advertising a new business on social media like Facebook. The employee, Barber, left to become a self-employed hairstylist. Despite the non-solicitation restrictive covenants in his contract, Barber had advertised the new business on his Facebook page, which could be seen by some of his former clients. The court found for the employee. So what can we learn from all this? Here's our checklist to help employers and employees understand who owns confidential information when using social media. Do include express covenants in an employment contract to protect confidentiality and non-solicitation. Do specify whether or not social media can be used for business purposes and explicitly reference contacts kept on social media accounts, including LinkedIn. Require employees to return their full list of contacts for business purposes, including ones on LinkedIn. Require employees to replicate contacts on social media on the employer's own database. Take steps to set up your employee's LinkedIn account, for example, using your company email address, and maintain the account using employer's systems, not personal ones. Express duty to promote the employer's business and develop connections in furtherance of the employer's interests. Impose a ban on updating LinkedIn during garden leave and tailor restrictive covenants to deal with LinkedIn issues. To close off, here's a reminder of how social media is the new normal. You can see some huge numbers in there in terms of uses every minute of every day. Your staff, boss, friends and family are all involved. There are new apps and uses every day. It's not going away. Thank you so much for your time today. We hope this has provided a useful introduction to the topic of confidential information and social media. Howard Havram focus on law for businesses, and our clients appreciate our straightforward, practical and commercial approach. We enjoy providing tips and advice for businesses that help them healthy and dispute-free. Don't forget to watch our other seminars in the series, and do feel free to get in touch if your business is in need of any legal advice.